Welcome back to the video series on making international in Korea. In this video, I'll be explaining on contribution to the developments of the law of the sea by Korea. Before 1948, Korea did not have a chance to contribute to the development of international law. At the time, the European-oriented international law began to regulate the interstate relationship of East Asian nations, which accepted international law. Western international scholars questioned whether Korea was a member of the international community as a sovereign state, and other scholars did not recognize other East Asian countries aside from Japan as subjects of international law, such as Korea, China, and Siam. Korea could not contribute to the development of international law under such circumstances, especially when the nation went under the colonial rule of Japan as soon as it opened its door to the West, resulting to the Japanese annexation. Upon gaining independence from Japan on August 15, 1945, Korea was finally placed in a position where it could contribute to the development of international law. However, due to how armed conflict between two Koreas destroyed most of the economic system in the country, and Korea experienced hardship which prevented it from participating in any meaningful activity to contribute toward the development of international law. Under this difficulty, however, a noticeable Korean state practice in terms of developing international law emerges, namely, the declaration by the President on the sovereignty of adjacent ocean, the so-called Peace Line Declaration. This declaration states that Korea has sovereignty over all the natural resources, minerals, as well as the marine products within a certain distance of water, including ocean floors in the continental shelf near the Korean peninsula. The declaration also allocated maritime sovereignty to Korea, far beyond the internationally recognized territorial limits. According to the order of international at the time, unilateral declarations and measures by Korea could be understood as violation of international law by infringing right of fisheries in international waters. Korea's such measures, however, can be viewed as pioneering, taking the lead to the changes of maritime law, influenced by the United States President's Continental Shelf Declaration and High Seas Fisheries Declaration, and Latin American countries' contention on the expansion of the oceanic jurisdiction. In the United Nations, the Law of the Sea Conference in Geneva in 1958, Korea, based on the purpose of the self-declaration, took a position emphasizing the special interest on fisheries of coastal states adjacent in international waters and stood against those countries that proposed freedom of fishing on the high seas. The Peace Line Declaration expanded the notion of exclusive fisheries zone to Asian region and subsequently contributed to establishment of the exclusive economic zone. However, Korea's contention of sovereignty over the continental shelf was not accepted by international community. Armed conflicts in Korea in the early 1950s also affected the development of international law. For example, the United Nations, with the absence of Soviet Union, have jointly identified North Korea as an aggressor and implemented the resolution under the UN Security Council to provide the assistance to South Korea. Due to the absence of the Soviet Union, the legal effect of the resolution was questioned based on the interpretation of the Article 27 of the UN Charter. Since then, the United Nations has held that the absence or abstention of a permanent member of the UN Security Council does not have an effect on the approval of the resolution by the UN Security Council. The UN General Assembly adopted a resolution of uniting for peace in order to avoid the Soviet Union's veto against the resolution as a response to armed conflicts in the Korean Peninsula. On this resolution, the special session of the General Assembly called the Special Emergency Session was formed, and the interim committee established in 1947 became meaningless. After the armistice agreement was concluded, the reparation of prisoners of war became an issue, and the concerned parties handled this matter in a way that respect the individual wishes of each prisoner of war. Such practice led to the insertion of Article 118 of the Geneva Convention relative to the treatment of prisoners of war, which prescribes that prisoners of war shall be released and repatriated without delay after cessation of active hostilities, which does not include forced repatriation of prisoners of war who do not wish to be back to their home country. The Korea-Japan Agreement of the Joint Southern Continental Shelf Development of 1974 was influenced by the 1969 decision of the International Court of Justice on North Sea Continental Shelf, and perceived the continental shelf as an extension of the dry land, which enabled Korea-Japan to jointly explore and develop natural resources in surrounding waters where the claims of sovereignty between Korea and Japan have been overlapped. This agreement has been viewed as one of the most important attempts of a joint development by putting an end to an issue of sovereignty over disputed waters. The initiative was also a key example that contributed to the development of international law by creating an international model on a joint development in the continental shelf as the first example which derived the consensus on the joint development based on the recommendation of the International Court of Decision in 1969. Furthermore, this agreement is also viewed as putting great significance on the development of maritime law by setting a precedent of the implementation of obligation to negotiate under general international law and the precedent of the implementation of negotiation duties under Article 83(3) under the Convention. Other than this, this agreement was a model of taking a tentative measure under the same article and being a model for duty of cooperation under Article 1 to 3 of the Convention. As a full-fledged member of the international community, Korea gave more statements and activities in meetings and forums related to international law. Korea's contribution to the development of international law became a common practice. To give a couple of examples, during the meeting in Rome for establishment international criminal courts, there were conflicting views as to system of acceptance of the international court's criminal court jurisdiction. One view was to adopt a method based on state consent, and the other view was to recognize automatic jurisdiction as to the crimes that fall under the universal jurisdiction. Amid this controversy, Korea suggests a proposal that one or more of the countries from origin of crimes, the countries of the detention, country of a defendant nationality, and the country of a plaintiff nationality that are state party to regulation of international criminal courts will accept the International Criminal Court's jurisdiction and jurisdiction of the case be recognized. This proposal was not accepted in the ICC statute, but was supported by many countries with the appraisal of an excellent compromise and evaluate as contributing to a final agreement to jurisdiction. Another example is that during the negotiation process of the amending to a 5 protocol to the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation, so-called SUA Convention, Korea contributed to making an amended SUA Convention in line with the existing order under the international law of the sea. In particular, Korea has been appraised to draw a compromise of inserting to the final protocol, understanding the definition of the related material that contained in the UN Security Council resolution of 2004 can be used in relation to the meaning of the dual-use material. Other than this, it has been also pointed out that Korea has contributed through civil organizations and victims that save victims of the military sex slaves to raise public awareness of the international community that sexual violence during the war is an intolerable crime as a massacre of prisoners of war or torture. On January 15, 2011, Somali pirate hijacked MV Samojoli, a chemical carrier flying the Korean flag, on the high seas in the northern Indian Ocean near Oman. The pirates, after gaining control of the Samojoli and its crew, appropriated and transferred to their mothership approximately $12,000 worth of goods, including laptops, watches, and cell phones, and shoes, and demanded ransom. However, South Korean Naval Task Force, the Cheonghae unit, headed by the destroyer Chaeyoung, had been taking the Samojoli, and as the pirates gave signs of preparing another hijacking, amount to the rescue operation on January 21. That effort ended in the death of the 8 pirates, including their leader, and the capture of 5 others. The crew was unarmed, except for the captain, who had been seriously wounded by the pirates. When the Samojoli entered the Yemeni port, the government sought to negotiate the transfer of the captured pirates to Yemeni judicial authorities for purpose of the prosecution in Yemen or Kenya. As the cooperation of those countries became difficult, the captive were returned to the custody of the Korean government and subsequently transferred to Korea on January 30th. Upon approval, the pirates were handed over to South Regional Headquarters of the Korean Coast Guard, which had jurisdiction over Busan, where Summer Shipping Company was located. On February 7th, after an investigation, the pirates were sent to Busan District Prosecutor's Office, which indicted them on February 25th on any account of criminal act related to piracy, the forcible taking the ship, forcible taking property on the ship, forcible operating the ship, demanding ransom to release the hostages, firing at soldiers, inflicting physical assault, threat, and bodily harm on the crew, using the crew as human shield, and firing on the captain. While the amendment does not specifically define the universal jurisdiction, it provides in Article 7 that this law applies to foreign nationals having committed one of the following offenses outside the territory of Korea. The article then enumerates the expansive list of the specific crimes to which universal jurisdiction would apply. It would also allow Korea as a state party to exercise universal jurisdiction under the SUA Convention by calling the crimes governed by it punishable pursuant to the treaties binding upon the Korea. Commendably, the defendant received a quick and fair trial for months from the investigation to a trial court verdict and 3 months from the appeal to the High Court decision, and each defendant was represented by the 2 Oregon counselors, even though the case involved the accomplices. In addition, the Somali interpreters were provided from the abroad, and the defendants' human rights were guaranteed through criminal procedure and the jury trial. But the case raised questions about the legitimacy of arrest under international law, in particular whether the use of force by Korean naval forces and the subsequent confinement of piracy conformed with Korea's international legal obligations. The traditional definition of piracy provided in the Article 101 of the UNCLOS referred to action taken for piracy and by the crew of the private ship, and the law of war, which apply to state or organized armed groups, do not necessarily apply to the suppression of such acts of piracy.